everyone, and welcome to this video tutorial on remedies in tort. Once a case has been made by a claimant and the defendant's case defeated, the court will decide on an appropriate remedy to apply to the problem at hand. Remedies come in two primary forms, damages and injunctions, and we've come across both of these before when we've been looking at different torts. So damages aim to put the claimant back in the position they would have been in had the tort not occurred. We looked at injunctions particularly when we were looking at nuisance, because they're going to be particularly useful in a nuisance case because they're a court order, usually instructing a person to refrain from doing something. Occasionally they can instruct a party to take positive action as well. So we'll look at each of these in turn. Damages, we know, are quite simply the award of a monetary sum to the claimant, which must then be paid by the defendant. And the general guiding principle is that of full compensation, this Latin here, this restitutio in integrum. And the idea is that the amount of damage awarded should return the claimant to the position they would have been in had the tort not occurred. An award of damages is made up of a number of different smaller awards which take into account different elements of the case, and they're all added together to reach a final lump sum. When we're looking at damages, it's important to recognise that there are lots of different types of damages which are available to the court, and we're going to have a look at these. General damages are also known as non-pecuniary losses, and they're damages that flow from the negligence and can't be given an exact figure. They can't be quantified at the time of trial, and they are more prospective in nature. General damages and non-pecuniary loss are broken down into pain, suffering and loss of amenity, and you can imagine here, you can see why this is difficult to put an exact figure on. Because how do you quantify a figure for pain, suffering and loss of amenity? That's very difficult to do. A big part of general damages as well is trying to calculate future medical care and future loss of earnings. A claimant who can't work at all will be able to recover their earnings for the length of their future career up until a likely retirement date. Sometimes a claimant will be prevented from carrying on with their current career, but they'll be able to take some other sort of work. Claimants don't have to work, but the court will imagine that they will in calculating their damages. In other words, claimants are expected to mitigate their future losses. And possible promotions can create a significant difficulty here, but as long as the claimant can show to the court that they were on a career ladder of sorts, which they were likely to ascend, they will be able to claim higher damages to reflect career advancement that they're no longer able to do. You can see I've included here the calculation that the courts use when they're trying to calculate loss of future earnings. So they take the multiplicand, which is the annual loss, and the multiplier, which is the number of years that the loss is likely to last. And this can help them to calculate a loss of future earnings. So if the person can no longer work as a result of the tort, the courts can calculate damages that they can give for that. Because they're difficult non-pecuniary losses to calculate, in Heel and Rankin, the Court of Appeal actually made the comment that they thought that non-pecuniary losses awards for that were too low, and for most severe injuries, awards should be increased by about a third. Lord Woolf has emphasised when he was looking at the civil system that compensation must always be fair, reasonable and just. But you can appreciate for these non-pecuniary losses, that is very difficult to do. There is going to be an element of subjectivity in it. On to special damages or pecuniary losses. These are much easier for the court. These are damages which can be specified at the time of the trial, so damages for injuries or costs which take place pre-trial. And as you can see, these sorts of damages may include the cost of repairing a car, hiring a replacement, the cost for replacing damaged clothing, All of these things are easy to calculate because you can produce receipts or invoices to prove precisely how much costs have been incurred. It can, as I've said, include loss of earnings and medical expenses that have already taken place. If there's medical expenses that you expect to have in the future, that will be non-pecuniary loss. Because it's not happened yet, you can't put a precise figure on it. But if it's happened before the trial takes place, that's pecuniary loss. You can evidence how much it cost, so that can be calculated easily. Loss of earnings before the trial come under special damages as well. So any wages you've lost up until the trial, they're easy to calculate. Future earnings, 10 years down the line, that's going to be non-pecuniary losses. We look at our next type of damages then, nominal damages. Nominal damages are a small financial award that are awarded when a claimant's rights have been infringed, but little to no harm has occurred, and they're often awarded alongside an injunction. They're only used for torts which are actionable per se. So we've studied trespass to land, that's actionable per se. And if you think about trespass to land, there's likely to be very little, if no damage whatsoever. If someone steps onto your land and steps off, there's no damage. So there might be a very small award given to show that there has been an infringement, but there's no real damage that has been caused. Contemptuous damages then, where the courts are of the belief that a claim technically has legal merit, but little moral merit, then they'll award what we call contemptuous damages to the claimant. This is often as small of an amount as possible, such as even a penny. And this is often to reflect the fact that the court believes an action shouldn't have been taken. So although there might have been a tort, they think the whole claim is ridiculous. They can be given for any tort, unlike nominal damages, though. Damages are those reflecting the fact that a case has been aggravated by one or more factor or another, usually for humiliation or distress caused to the claimant. To give you a little example of this, in Appleton and Garrett from 1996, the court gave aggravated damages to reflect the emotions felt by the claimant in the case at hand. So aggravated damages allowed the court to take into account of abstract injury to the claimant's feelings, as long as the claim itself is based on something more concrete. Exemplary damages are similar to aggravated damages, but rather than stemming from injury to the claimant's feelings, they stem from the defendant's own poor behaviour with the aim of making an example of their conduct. They're sometimes called punitive damages, and these are damages whose purpose is to punish the defendant for committing the tort. They're very rarely used because, if you remember, the main aim of compensation in tort is to put the claimant back in the position they would have been in. Tort isn't usually used for retribution, for punishing a defendant. We use punishment and retribution for the criminal law, not usually for tort. But it can, as we've seen in Rooks and Bernard, exemplary damages can be used to punish the defendant in rare cases. And Devlin identified 3 circumstances that were quite limited where exemplary damages would be awarded, such as unconstitutional action by servants of the government and basically abuse of power. So quite limited circumstances that these will be awarded. When looking at damages, we have to comply with the mitigation principle. And the mitigation principle is roughly that a claimant must act where reasonable to mitigate their own losses. And this is important because the cost of many heads of damage could be artificially inflated by a malicious claimant. So a person is supposed to keep their costs to a minimum. So, for example, where a person's been injured due to negligence, the injured person can't claim for private treatment if there would be a suitable treatment under the NHS. Obviously, if there's damage to property, you can't claim for a more expensive item than was actually damaged. So you've got to mitigate your losses for fairness. In terms of payment, originally the only option open to the courts was lump sum payments at the time of the judgment. But the Damages Variation of Periodical Payments Order was passed, which allows the court to rule that damages should be paid periodically and then reviewed upon the deterioration or improvement of the claimant's injury. And although there was a point at which certain judges would award extra damages to account for inflation, this is now not the case. It's assumed that claimants will have the foresight to invest or save their lump sum in a way which will deal with inflation. So we used to have lump sums, but the big problem was people might spend it all in one go, and it wouldn't be good with people who weren't great at investing their money. Nowadays, we tend to go for periodical payments, so you'll get your damages, an amount of them will be paid into your bank every month. And that will happen for the rest of their lives. It's normally paid by insurance companies. And this is particularly good for children, people who are not good with their money. They're not going to spend it all in one go. But of course, the problem is we don't know when a claimant will die. So if you're splitting up their damages for every month that they're likely to be alive, if they die a lot sooner than we expect, you could argue that they've been treated unfairly because they've not received the full extent of their damages. I'd like to remind you of the case of Masha Najib, which we've looked at when we were looking at the civil system, because this is a really good example of damages in tort, because this was the largest payout in medical negligence history, where the NHS faces a £24 million payout when glue instead of dye was injected into Masha's brain. It's also an interesting case to look at because obviously it shows the problems with non-pecuniary losses, with working out a suitable amount of damages to account for loss of amenity and pain and suffering. And I've given you a breakdown here of when Masha will receive her payments and how it's broken down. So that's quite interesting to look at if you want to pause the video here for a minute. Injunctions are the other main type of remedy in tort, and it's a declaration by a court that the defendant must behave in a certain manner. And they come in two main forms: prohibitory, in which the claimant is prohibited from doing something, and mandatory, in which the defendant must do something. As well as being either prohibitory or mandatory, you can have quia time or final or interim injunctions as well. Injunctions are an equitable remedy, which means they are a matter of court discretion. And whilst damages are available for all eventualities, injunctions are not. Whether they are granted depends on the will of the court. And their use tends to be limited since they involve essentially overriding the will of an individual or an organisation. Quia time injunction means because he fears, and this is an injunction that's used when the claimant fears a tort will occur, but it hasn't happened yet. And the prerequisites which must be fulfilled before they're granted are that there must be evidence that the defendant is intending to take an act. The act must be one which will cause significant irreparable damage to the claimant, and there must be evidence that the defendant will not desist unless a quia time injunction is granted. Or interlocutory injunctions apply when the tort is ongoing or else where there's a high chance of it recurring in the near future. By definition, they're temporary, and their use is particularly restrained since they're essentially a remedy which is applied before a case has been properly heard. And they'll only be granted if the claimant undertakes to pay damages to the defendant for any loss caused by the injunction if it's later found that the claimant was not entitled to stop the defendant from what they were threatening to do. Injunctions are simply those which are granted after a tort has been committed, but where it's likely that the tort will reoccur. And these are particularly useful, as we've already said, in the tort of nuisance claims. And just to end here, since injunctions are an equitable remedy, they're affected by the principles of equity law. So some of the rules of equity are here, and the court will consider these rules of equity when deciding whether or not to grant an injunction.